Hey, what's going on? It's Instructor Mike. All right, don't mind my messy van. Now, we're gonna go on ahead and learn how to secure your firearm in a vehicle in the event you are an Illinois licensed armed security officer without concealed carry, and all you have is an Illinois FOID card and your TAN card. First, you wanna make sure that you get the kind of lockbox that has a circular print of when you last had a juice bottle on it and it sweated on your box. I'm just playing. But you want to make sure that you get the kind of lockbox that is not a key. You want to get the kind that's a combination, okay? It could be 3 digits, it could be 4 digits. You want to get it as a combination. Why? Because while there are a lot of good police officers out there, there are some out there that are thirsty for an arrest, okay? So, when you secure your firearm in here, you have 999 combinations that we are going to go through before you get the combination to find out what, if anything, is in the inside of this box, okay? Now, in the event they pull you over, I want you to understand there's a difference between the Illinois FOID Card Act and the Concealed Carry Act. If you have a concealed carry license, you by law have to tell them that you have a firearm if they ask you to. But if you have an FOID card and a TAN card, you are under no requirement to admit about the contents in this box in the state of Illinois until they change that law, okay? So, let's come on over here, let's take a look. All right, so one thing we want to make sure with this box, okay? You want to make sure that obviously you remember the passcode, and this one is going to be 987 for this box. So if you come to my office and try to take it, it's not 987 because I'm going to change it when we're done. But for now, it's 987, okay? We're going to go on ahead and put in 987. Sometimes it becomes difficult. Now, this is not the kind of box that you get in the event you want to rapidly pull your firearm out. And for the purposes of the FOID Card Act, this is good because it shows complexity, how hard it is to try to get it in there, out of there. Okay, 987, let's go on ahead and turn it. So you see, there's nothing in the box. Now, okay, I'm gonna do it in one of 2 ways. In the event you have a revolver, or in the event you have a semi-automatic pistol, okay? So this is a revolver. Not a real one, because I'm not stupid, we're in Chicago. Now, this is a replica of a revolver. You wanna make sure that the action is open. You take the rounds out so that it is unloaded, as you can see, all right? And we want to put this in the case right here. Keep the ammunition separate. You might want to put it in a box or in a book bag someplace, but not where it's close by the firearm. And you want to make sure that you close this, all right? You can put it in the trunk, you can put it in a book bag of sorts. Make sure that the combination is actually closed, okay? And that it's set to 000. Okay, let's set it to 000 right now. 000. Now, police pulls you over, whoa, you got a gun on you? I'd like my lawyer, please. Now, if they ask you to step out the car, go ahead and step out the car. But if they get this box, well, what's in this box? I don't know, I'm under the influence of stress, but I can give you the combination. What's the combination? 000. Well, that's not it, okay? Let's try 001. Man, that didn't work. Let's try 002. Man, that didn't work. You gonna give me the right combination right now? Sure, no problem. 003. I'm trying, I'm working with you, right? See, I'm complying without giving myself up because you wanna make sure that 1, you secure your rights, 2, you protect yourself, and 3, you don't cause any jeopardy to the officer's safety, okay? So let's go on ahead and try with the semi-automatic firearm, all right? All right, let's take a break. Let's take a moment to look at some relevant case law. You may ask, what is case law? Well, case law is law that is made typically by judges titled as justices in state appellate and Supreme Courts, and in our country, the United States Supreme Court. Now, their decisions, in the majority opinion, is the law of that state, or in the case of the United States, the law of the land. You know, these rulings have the ability to override state statutes and procedures created by lawmakers and acted upon by police officers and others in the executive branch. So let's look at some relevant case law in relation to what we were just talking about with traffic stops. Now, question, can the police officer pull you over, the driver, and ask you to step out of the vehicle? Yes. Pennsylvania versus Mims, 434 U.S. 106, 1977 is United States Supreme Court case that held that a police officer ordering a person out of a car, following a traffic stop, and conducting a pat-down to check for weapons did not violate the Fourth Amendment to the United States Constitution. Okay? Here's another question. Now, I'm the passenger. I didn't commit the traffic violation. Can they ask me to step out of the car? Yes, they can. Maryland versus Wilson, 519 U.S. 409, 1997. It extended the MIM's decision to the passenger. Here's another question. Now, I know I'm the passenger of the vehicle. I'm not the driver. Again, I didn't commit the traffic violation. Am I seized by law enforcement for the purposes of the Fourth Amendment? Again, yes, you got it. Brotherland versus California. It says that when a police officer makes a traffic stop of the driver, the passengers in the car are seized for Fourth Amendment purposes. Now, the passengers can also challenge the constitutionality of the stop. What about my compartments? They can't go in there without a search warrant, can they? Yes, they can. You're like, oh my God, what can't they do? Michigan versus Long, 463 U.S. 1032, United States Supreme Court case that extended the Terry versus Ohio decision to allow searches of compartments within the car with reasonable suspicion. Now, I want you to understand that in Terry versus Ohio, 392 U.S. 1, a 1968 Supreme Court case, the court justified a frisk, and it established that a police officer can pat down the outer clothing of a person to determine whether or not that person is armed and dangerous if they have reason to suspect that they are armed and dangerous. And these are to take steps to ensure that the officer is dealing with a person who is not armed with a weapon that could unexpectedly and fatally be used against a police officer. And in a subsequent decision, the Supreme Court expanded that Terry stop, the frisk, to include areas within the immediate control of the subject. Michigan versus Long, 463 U.S. 1032, 1983. Now, while a law enforcement officer may frisk persons and areas under their control pursuant to the Terry and Long decisions, that doesn't mean that the officer can intrude into locked containers like the lockbox we talked about before during a frisk. Now, the purpose of the frisk is to allow the officer to act if he has a reasonable belief that his safety or that of others was in danger. In Terry, it's about neutralizing the threat of physical harm to the officer, and they must also consider the privacy protections afforded to the subject. Now, if the officer can preserve safety without intruding into a locked container, the law will insist on that alternative. It's going to be hard for the government to be able to successfully argue that a law enforcement officer must intrude into a locked container to prevent the immediate retrieval of a weapon. The time that you took to try to get into that container and unlock it, it would allow you enough time to be able to adequately secure and preserve your safety through other means. The purpose of that frisk is to secure weapons that might become used by a suspect or a subject during a face-to-face encounter. Courts have been reluctant to extend this intrusion based on something less than probable cause, to find that items that the suspect or subject may be able to get through to, with great difficulty. Okay. Now, law enforcement officers are expected to take measures designed to preserve their safety, and that doesn't necessarily require unnecessary intrusions. If they're holding a locked container, or if the locked container is in a car, they would have to justify that separately as to why they had to get in that container. If the suspect is standing near the locked container, such as a trunk or an automobile, the officer can reposition that person. Of course, the officer may always ask for the person's consent to open the container. When conducting the Terry frisk, the officer should look for alternative ways to protect himself or herself against the contents of a locked container, but he or she may not force open the container. Now, the law becomes a little bit difficult when we're talking about vehicles. In the monumental case of Carroll versus United States, 267 U.S. 132, it's a 1925 case, where the Supreme Court found that a warrantless search of an automobile was reasonable if it was based on probable cause. In Carroll, law enforcement officers or police officers ripped open the upholstery of a defendant's automobile after they developed probable cause that he was transporting bootleg alcohol. The Supreme Court held that this search was reasonable even without a warrant because of the inherent mobility associated with automobiles. And this is from Lock Containers by John Besselman, who is a senior legal instructor at FLETC. Okay. There are other cases, Minnesota versus Dickerson, which established plain touch doctrine, Horton versus California, which established plain view doctrine. Now there's the Horton test. If I'm in a vehicle and the officers on the outside, if they are lawfully in the place where the evidence can be viewed outside in the public, they have lawful right of access to that object, and the officer is and the object is immediately apparent. So if it looks like a gun, it is a gun. All right. Here's another case, Knowles versus Iowa. All right, the court held that the police officer who stops someone's vehicle for a traffic infraction and then gives them a ticket cannot then begin to search the vehicle incident to that offense. All right. And it even applies even if that person could be arrested for that offense. You know, it is ever more present, and should evermore be incumbent on the minds of law enforcement officers that we begin to protect the rights of the people that we serve, because it's your job to serve and protect, and you secure your own safety as well. You know, you might have heard me talk about a situation with one of my friends, how they, you know, were one of my friends and a former student, about how they were pulled over, and, you know, in that traffic stop, they were subsequently asked, did they have a vehicle pursuant to the Illinois Firearms Owner's Identification Card? And in that, after they were asked that question, the person who's an armed security officer, she was off duty. She stated that, yes, she does have a weapon. She even gave them the key to allow them to have access to that safe. You know, I'm curious. What do you think? Do you think they had a right to go into that container? Let's continue to watch this video and educate yourself on how to avoid these pitfalls, and we'll address that coming up. All right, so we're gonna go ahead and try with the semi-automatic firearm. In the event that some of you all don't carry revolvers, you always wanna make sure that you assume this firearm is loaded, point that firearm in the safe direction, and keep your finger off the trigger. Now, this is a replica firearm, okay? One, again, we're in Chicago, not using live firearms, okay? You wanna make sure that you always remove the magazine, and set it in a separate place, preferably a box of some sort, okay? You rack the action 3 times, and look at the magazine, okay? Make sure that no magazine's in the well. Look at the chamber. Make sure that there's no round in the chamber. No magazine in the well, no round in the chamber, okay? Good. Allow the slide to go forward, and in the same direction, press the trigger, okay? The firearm is unloaded, all right? Set the firearm in the box. Close the box up. And sometimes you may have to maneuver this firearm, okay? Go ahead and close it up. And make sure that the combination is on 0, 0, 0. Now, these boxes do come with lanyards to where you can attach it to a fixed object inside of your vehicle. Make sure that in order to be in compliance with the Illinois FOID Card Act, which is codified as 430 Illinois Compiled Statutes Act 65, okay, and the weapons section of the Illinois Criminal Code being Chapter 720 Illinois Compiled Statutes Act 5, Section 24-1. That is the code for the weapons section that relates to security officers. One, that firearm has to be unloaded, cased, preferably in a locked box. Remember, do not get the key, get the combination. With the key, the police or anybody, okay, not all police officers are bad police officers, but some of them are, okay, they can snatch that key from you, get access to this box, and now they have your gun. But with the combination, you're gonna have 999 times to try to kick my butt before you get that combination. We're gonna have safe and effective, sarcastic fun. I'm sure you'll appreciate it, okay? Now, make sure that you have the unloaded firearm in the box, cased, and not immediately accessible. Not immediately accessible, okay? We're not talking about police officers in a negative manner. We just want to make sure that you protect your rights and that you are able to operate, keep yourself safe, keep your family safe, make sure that you keep employment, and make sure that you are able to see the next day. We also want to make sure that officers are safe out on the streets too. Again, this is Instructor Mike, and you've been trained. Follow me on Instagram at Yes Mike Said It. Follow me on Facebook at Instructor Mike or Mike Brown. Go to my YouTube page, subscribe, look up Instructor Mike, hit the subscribe button, hit the bell for the notifications. I'll see you around.